suggesting that one of the days
Yes, I would.
when the case is currently listed for final hearing be taken up with an adjourned issue resolution.
Yes, I wonder if we can at least productively use maybe even the first 2 days, the Monday and the Tuesday. I don't know whether that affects the court's diary, but if we could literally have that opportunity when everybody's seeing everything that's been filed, and the guardian and the children's solicitor will have used the time to go and talk to girls, and if we can get some representation for them. I'm not saying that we can resolve this case. I'm not saying that will be the outcome.
Saying it's a good prospect.
But the Guardian still has hope that there might be some prospects of salvage. Maybe we use a couple of days in that week. If there are contentious issues, they're not going to be able to be resolved. But I think it's just an aspiration to try and use something that week.
Is the Guardian in favour of the supervision?
Yes, I don't, but that's not a difficulty. I know the Guardian was anxious about there being no public law order and leaving the mother effectively rudderless.
If
so,
you've
yes.
said this, and I've not picked up, it's my fault, but have I heard from you what the Guardian's view is on the objective assessment of the best interests of the children, as between living with their mother and living with their father?
You haven't, and the reason I'm hesitant about that is that really what the Guardian had, her hope had been, and again it's something that she's going to want to develop with the parents and girls over the next few weeks. She had hoped that they might be able to, as parents, reach a resolution about what was best in terms of their arrangements for their children, rather than it being simply, well, they're living with you, they're only seeing you. I think she had seen it more as a way of negotiating seems the wrong word, but yes, negotiation was the wrong word. But, and she had felt hopeful for that. But on the other hand, of course, the Guardians understood very clearly both parents' frustrations, which were then translated, which they are, as Your Honour knows, to girls who are 14 and 13 who know what's going on and have their allegiances and their loyalties.
Yes, very sound common sense, if I may say so. That's what expects from the Guardian, who is independent of the parties and take an objective, fair-minded view. God blessing in this case, then. Great happiness about it is this is a public law case, but nobody's saying the children need to be removed from their family. It's not really the element of the private law case in which the court, if it has to, and I hope it doesn't, has to choose between care by mother or care by father. And that's always best sorted out by compromise between two loving parents. That's the Guardian's position.
It is.
Today.
It is.
Asked wherever they live, they're going to need to see a lot of the other parent.
Absolutely. Because these children have, in living with their mother, they have established a very good relationship with them and a very good attachment to them. And it's about balancing that. And their overwhelming love for their father.
Yeah.
And the Guardian is still hopeful, even now, of trying to make something work.
Right. Well, I'm indebted to all the advocates who addressed me about their respective positions, but I'm particularly indebted to the Guardian, who Lewis Garth was persuaded me that there is some prospect of finding a resolution for these children, which makes their parties and the children themselves, who understandably want to be involved, in the agony of conflict with the court case. So, nobody actually opposing what is in effect an application by the Guardian to adjourn the final hearing, but to keep the case in the list for up to 2 days to see whether middle ground, sensible middle ground for the benefit of the children can be achieved. So how that compared to the journey or application that treats putting I've never done this before, given an IRA 2 days, but I'm prepared to treat day 1 and day 2 as issue resolution. Be available at all times to hear submissions and if necessary some brief evidence to see whether we can resolve the case.
I just wonder, Your Honour, given that, as I understand it, the case had remained in the list for 4 days, the Monday through Thursday of the week of the 23rd, whether keeping the Wednesday and Thursday, the latter 2 days, does allow extra time for the various discussions that the Guardian has outlined needs to take place, buys 2 extra days. It's still more than a suggestion. I realise that the local authority is entirely in the hands of the court and the others, given its part in what has happened today. I make that suggestion.
Wednesday, Thursday.
Yeah.
And I think it concentrates people's minds if we
Keep it on
keep it on Monday.
Very well. I
It
don't
must,
know.
it must all be available for Monday, Tuesday,
Quite.
because
Yeah.
it's currently in the electronic diary for 4 days. Starting on Monday,
Yeah.
23rd.
Did you want me
The only invitation is time for parents to respond to statements. We just understand additional time parents should reflect and of course read difficulties that might give the client. I appreciate capacity, but doesn't matter. It might assist with the overriding fair.
So you're getting what is coming now from the local authority by 4 o'clock today.
tomorrow, Your Honour?
Was the timetable already paid for the final evidence? Parents?
It does, but would be on those dates, Your Honour, because the local authority didn't comply with its own dates.
I don't think I'm trying to put any obligation on the parents to file any discards advocating Swan River Road for the role of talking to one another while reading.
Yes, I mean, I think the Guardian's time is best used now, going and sitting down and talking with Mum and Dad and the girls.
Yes, I agree.
And we can everyone can file position statements on the Friday before we
Position
return.
That's
Before we return to
2 sides of
you.
it. On Friday.
Yeah.
Distribution.
And we can come and see you,
Yeah.
perhaps maybe 2 o'clock on that Monday and have an advocates meeting in the morning.
Well, that's truly important. Very generous offer by the Guardian to do this mediation. I take it Mr. House is prepared to talk to the Guardian.
I have done, yeah.
Good. All the lawyers do far too much reading in these cases, not enough listening. I mean, the judges actually. And I just wish in more cases the parties could do more talking than writing. Now, that's a good way forward, I think.
Certainly is. And listening,
Miss McNulty, your time sitting there.
understanding, lying.
A very experienced guardian who's got the best interests of the children at heart, so I've got what she's got to say is great of you. Pleasant litigation because the fallout can't succeed. Who would benefit greatly from getting some news that their mother and father are agreeing things? It's always joyous for children to know that mother and father, although living separately, can agree on things about. So I see the case. You're going to draw all this in an order, are you, Mr. Brown?
Yes, Your Honour, can I just be clear about what is being directed then? So the local authorities' statements will be 4 p.m. tomorrow, an adjourned IRA on the 23rd and the 24th of February, an advocates meeting on the morning of the 23rd of February, So listed not before 2 o'clock, for Your Honour, on the 23rd.
I'll be here. Are you
Well,
going
I
to be in the
said-
building?
Yes. Yes, that, well, I simply listed on those 2 days, and then position statements by 4 p.m. on the preceding Friday.
I listed at 10:30.
Yeah,
I about the 23rd.
I will.
I'll be working in my room and I can see you anytime.
Is Your Honour content for me to send in that order electronically today? Or
Yes,
do you-
so,
I'm grateful.
all right. So we next see each other on the 23rd. Skip.
Your Honour, yes.
Thank you very much. All right.
Oh,
Come and talk to you and I'll sign it tomorrow.